state case to come before the court this morning is, the appellant is David McGrew, Mr. Sharon McGrew. Each party will have 15 minutes in which to present the case. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the time and we'll keep track of past time. We are being visually and audibly recorded, so please try to stay behind the podium as much as possible. We have been ready to brief, so we're ready to proceed with the remarks.
Thank you, Your Honor, and I would like to reserve 3 minutes for rebuttal, and so you could program everything accordingly. May it please the court. My name is Gary Rosen, and I'm pleased to be here on behalf of appellant David McGrew in this matter. As this court knows from having reviewed the briefs, the procedural history of this case is rather long and complicated. The parties were married in 1991, had 2 children, and the divorce proceedings began in June of 2011. The divorce trial was subsequently held over a number of dates starting in June 2015, concluding in July 2015. The decision was rendered by the trial court in June of 2016. I will indicate to the court that in our brief, we briefed 5 distinct issues. Knowing my time limitations with this court, I'll try to restrict my comments to 3. Hopefully I get that far. I will note to the court that amongst the 5 issues was an issue about taxes. I can indicate to the court that that issue has been resolved, just so the court knows, to appellant's satisfaction through action by the Internal Revenue Service. He is very satisfied with that result, and there's no need for this court, I would indicate, to rule on that particular issue. Let me then deal substantively with the remaining issues as best I can within the time frames that I have. And I'll start with the issue with regards to the certificate of deposit, the CD, at CF Bank, and the court's ruling that it was both a marital and a separate asset. Now, there was a stipulation, this court will note in reviewing the transcript, that certain assets were separate assets of Mr. McGrew. And as related to the CD at CF Bank, what was in particular relevance for that is that there were assets in his father's trust. During the time of litigation in this case, which lasted 4 years, as this court will note, one of the parties' businesses was in financial difficulties, and there was a need, actually this occurred, I would indicate to the court before the litigation, there was a need to help shore up that business. And Mr. McGrew drew upon resources that were separate, created a CD at CF Bank entirely from assets from his father's trust. The tracing is clear and unequivocal and was uncontested at trial.
Actually, it was stipulated, wasn't it?
Yes, it was, Your Honor. Yes, indeed. So the CD we know is separate property as it was created. What was it used for? It was used for collateral for a marital debt, because the bank would not continue to extend credit without collateral. The credit was extended. The business lasted for a period of time thereafter. Payments were in fact made on that debt during the litigation of the case, although I would note to this court, since the trial court made an issue of whether or not payment was made in its entirety, payments were made during the litigation of the case, even though Mr. McGrew was not ordered under temporary orders to make those payments. In fact, his income from the business was used as the underlying basis of the temporary orders for his obligation to meet his personal expenses and to make support obligations. So clearly he was drawing income from the business as he was directed to by virtue of the imputation of $70,000 of income from the temporary orders. But the debt was not paid off in its entirety. It was paid down from $80,000 to $50,000 approximately. And there remained, during the litigation of the case, about $50,000 still owed by the underlying marital business. And the court, I see a question coming, yes.
Well, it's my understanding that it was collateral. Was
Yes.
it ever tapped into by?
That is absolutely correct, Your Honor. It was never tapped
It was
into.
never tapped into?
No, Your Honor, it was not. That's correct. It was never tapped into. The CD itself was never used. It was merely collateral. And the analogy I would want this court to think about in the context of domestic relations law, as I know this court is familiar, is the very common situation where separate assets are used as a down payment for what turns into a marital residence. Common issue that we see in domestic relations cases. This court, other district courts have had a whole line of cases with that. And even though it's used for a marital asset, as long as you can trace, you receive that separate asset at the end of a divorce.
When the divorce was final, what was the status of the balance of that debt that was owed?
The balance of the debt was approximately $50,600. I'm off by a few dollars, Your Honor. And the CD was about $54,000. Again, I'm approximating.
So as of today, what's still owed to the bank?
Approximately $50,000, Your Honor, yes, yes. And the court deemed that to be a marital debt because it was a marital business. And so the debt that was owed was a marital debt, but found this asset, which was traceable back to separate assets, to be transmuted now, and the $50,000, again I'm approximating, $50,000 of the CD to be marital, but what above that, which was about $4,000, well, that could be separate. And that's exactly what the trial court said in the decision, which I will propose to this court does not make sense, is not logical, and is not consistent with case law. Let me move, since I have limited time, to a second issue, which is the medical bills. The court found that certain medical bills were exclusively the debt of husband. A little bit of background on the history of those particular medical bills. They were incurred during the litigation of the case and incurred on behalf of the party's daughter, who has special medical needs. In fact, the transcript has numerous quotes from both parties, from both husband and wife, indicating that neither one of them fully understood the medical issues. They subsequently reached a stipulation that the child is a castle child, requiring continuing needs and continuing jurisdiction of the court. But there was never a clear and unequivocal diagnosis for the child. And in fact, what occurred in 2012, so during the litigation of the case, is that the child's pediatrician, the child's own doctor, suggested further diagnostic testing. And the transcript, which I will specifically direct the court to pages 123 through 129 of the transcript, there's an outline by Mr. McGrew during his testimony about how he took the direction of the party's pediatrician. The pediatrician suggested, go out of state, go out of the area, let's get some additional testing from people who haven't seen this child before. He did that. He used connections that he had at the University of Kentucky, found very qualified people there who did some diagnostic testing. There was some follow-up at SUMA, and about $9,000 to $10,000 worth of medical bills were incurred.
But did he discuss this with his wife?
Did
they have an agreement to do this? Did they discuss it? Was she aware
Well,
of it?
I will differentiate your question, Judge, with the terms discuss and agreement.
Okay.
All right? Was there and I will answer first by saying there was a series of emails to wife telling her that he was doing this. Your Honor...
That doesn't sound like a discussion.
Your Honor, I'll put in the context of a difficult divorce case where there was relatively little dialogue between the parties. And the transcript you will see, if you've not already reviewed, you will see that there was precious little dialogue between the parties on medical issues. And Mr. McGrew testified during trial that he was extremely frustrated that wife was not providing with him regular communication about the child. And so, Your Honor, I will be the first to tell you that in this case, as in many others, there was not good dialogue between the parties. But was there notification that he was doing this? Yes, Your Honor. In fact, at trial, wife attempted to say, well, no, I didn't get it. I blocked emails from husband. In fact, it was demonstrated at trial that the blocking of the emails occurred about 8 or 9 months after the communication with regards to this medical testing. So in fact, there was no defense to the issue that, in fact, she got emails that he was doing this. But back and forth dialogue, no, there was not. Yes, Judge.
If there's no diagnosis, how is she a castle child?
Well, the parties stipulated to it, so I'll just start with that as kind of getting to the answer first. But there was a recognition that the nature of her issues were such that it met Castle without it, but did they come up with a specific diagnosis, specific prognosis? No, Your Honor, but I will indicate the stipulation was reached not too long after the testing that I described to you for these medical bills. So I'll go back to Judge Teodosio's question. Was there much dialogue or discussion between these parties? No, there was not. But ultimately, there was a recognition by both of them that the nature of the problems, whatever they were such that both parties were satisfied it met what they understood to be a castle definition. Let me move to the third issue, as I may, which is the award by the court for attorney's fees. The trial court awarded wife $25,000 of attorney's fees, which rather coincidentally almost precisely matched the property settlement that the trial court awarded to husband from wife, within a few $100s. So that at the end of the day, only a few $100 got exchanged. And the trial court's basic explanation for awarding the attorney's fees was that husband caused great delay in the case. And I'm summarizing, obviously, due to brevity. Husband had multiple attorneys. One attorney died, Attorney Jim Brown, who many of you may have known. For a period of time, he was pro se. But at no time was he found to be a vexatious litigator. At no time was he found to be in contempt. And at no time was anything summarily dismissed that he was raising to the court. Did he file motions while he was pro se? Yes, he did. About 6 over the course of about a year and a half. Did the other side file motions simultaneously? Yes. And the trial court said, well, there were numerous pretrials. I will submit to this court, a trial judge has complete control of his or her docket. A trial judge can determine whether or not an additional pretrial is appropriate and necessary or not. And a trial judge can say, we've had enough, it's time for trial. I'm confident all of you understand exactly the issue that I'm raising with that. And a trial judge then can't call the parties to the carpet for delay when a trial judge allows attorneys to withdraw and then to come onto the case and schedules multiple pretrials, and I would note ironically then take a year to decide the case. But it was on the basis of delay that the trial judge said that husband should pay an additional $25,000 to wife. Thank you, Your Honor, very much.
May it please the court, my name is Tom Houlihan. I'm here on behalf of the appellee, Sherry Greger, formerly Sherry McGrew. And I'd like to address first the first assignment of error concerning the certificate of deposit and why it was transmuted to marital property by the trial court. It's important to understand that the business, MCS Marketing, was managed solely by the appellant, David, at all relevant times, and that there were 2 outstanding debt obligations that MCS Marketing had. First, as was discussed, there was a loan to CF Bank in the approximate amount of $50,000. The term $80,000 was indicated in counsel's oral argument that it was taken out for $80,000. There's no evidence of that in the record. If you look at the court's decision at page 11, it discusses that the plaintiff, Mr. McGrew, applied to Cuyahoga Falls Bank for a $51,200 loan. That's at page 11 of the court's decision. There's no indication that it was an original amount of $80,000, nor that it had been paid in any significant amount over this period of time. The other source of financing for MCS Marketing was a series of loans that Mr. McGrew made to the business from another source of separate property, an inheritance he had. And the evidence is clear that during the divorce litigation in 2011, 2012, and 2013, he made preferential payments to himself rather than paying CF Bank, the third party, to exhaust that debt. So if you look at transcript pages 221 to 234, in 2011, Mr. McGrew paid himself, instead of CF Bank, $15,000 in principal and $2,938 in interest. In 2012, he paid himself $19,000 in principal and $2,721 in interest. And in 2013, he paid himself $26,000 in principal and $3,006 in interest. He was in total control of the business, and he was preferentially exhausting his own debt to himself in order to leave this marital debt to CF Bank as an obligation that would have to be shared by Sharon McGregor. So, in view of this, the court explained its reasoning on pages 11 and 12 of its decision. Since David was in total control of the operations of MCS management, he was on all sides of each transaction, he was able to manipulate what debt got paid and what didn't. He paid down the loans that he made, rather than the loan to CF Bank, and sought to saddle Sherry with half of this marital debt that otherwise could have been exhausted. So as a result, looking at the use of this certificate of deposit that was used as collateral for this CF Bank loan, despite the fact that it was unilaterally obtained separate property by David, he used it to support a marital asset, the business, MCS Marketing, and to secure a marital debt. Accordingly, the court, using its discretion, under the totality of the circumstances, transmuted a sufficient amount of that CD to offset her half of the debt that he engineered that she would owe. That's what happened here, and it's explained in the court's reasoning on pages 11 and 12. But I want to make sure this court understood there were two different financial obligations that this business had. One owed to a third party, which is unquestionably marital debt to CF Bank, and also this debt to the appellant himself. And his choice in paying himself preferentially is what led to this decision by the trial court.
Did wife benefit in any way from him doing that?
Not that I can think of.
If he hadn't paid himself any of that money while he continued to operate the business, and the business was losing money, could he have filed for temporary spousal support in the intervening months until the divorce was final?
He could have filed, but at the time, I don't think she would have had sufficient income to have paid temporary spousal support. I think she was making $38,000 a year.
So she wasn't receiving any payments of any kind from the business that he was continuing to operate, that she had?
No. She was actually the record owner of this business, but the evidence at the trial was clear that she was the owner because he wanted to pursue minority-owned business contracts with the government. She never had a role in managing the business, and she didn't receive any payments from it after the divorce was filed and the parties separated.
So wherever the money went that he paid, if he had paid off the CF loan bank loan, the business wouldn't have owed that money anymore, and the collateral would have gone away, wouldn't need it anymore. But when the business went under, the business still would have owed him money for loans that he made.
Correct.
Would she have been responsible for any part of the money that the business loaned to him?
I don't believe so, because he was in control of whether or not he poured more money into the business.
She
And
owned
this
the business.
occurred.
The business was in her name, though.
Right. But the evidence is clear that she wasn't making those decisions, didn't have a part in it.
Did she ever get any tax benefits from any of that?
She did receive some tax impact from it, which was the issue that was set forth in Assignment of Error 2.
Arguably, that wasn't a benefit.
Arguably wasn't a benefit, but it's now resolved. So the question is, can Mr. McGrew decide which debt to pay to his advantage while managing this business after there is a temporary order in July of 2011 saying you can't create new marital debts? He engineered keeping an old marital debt alive. By the way, he paid which debt was out there.
Was she aware of any of those payments going on at the time?
I don't believe so. I don't think that's in the record.
Why wasn't a receiver appointed to manage the business?
I don't know.
Was one asked for?
No, not as far as I can tell from the record, which is, the docket is extremely long, 21 pages when I printed it out, but I didn't see a request for a receiver in the documentation. So with respect to the certificate of deposit, I think the court made a well-informed, well-reasoned, well-supported decision to balance the equities using its discretion to divide marital assets and debts. Certainly, there is some competent, credible evidence that supports the court's decision, and this court is obligated to employ a highly deferential standard of review when deciding whether or not the trial court made the right call in that regard. So I would suggest that the court be affirmed on that basis. With respect to the medical bills, again, I need to note that the parties were under a temporary order as of July of 2011, July 1st, 2011. A mutual restraining order case management plan was put on that prohibited either party from creating marital debts without the consent of the other. Notwithstanding that order, Mr. McGrew decided he was going to go investigate whether or not the existing diagnosis of hypotonia was an appropriate diagnosis for his daughter, Shannon, during the time when there was a question as to whether or not Shannon would be treated as a castle child. Accordingly, he unilaterally found a team of physicians in the Kentucky area and drove her down for diagnostic testing. There's no evidence that there was any treatment provided, nor is there any evidence that information that these diagnostic tests the information from the diagnostic tests and the meetings with doctors in Kentucky were ever supplied to Shannon's personal physician to assist in her treatment or care. This was purely an investigatory effort to fight the fight over whether or not Shannon was a castle child. As such, as the court concluded on page 15 of its decision, it was his separate debt and his separate responsibility. Judge Tito, so you look like you have a question in trouble.
Well, I'm just thinking, you've got a special needs child. Wouldn't it be a valid marital purpose to try to figure out what the best course of treatment is, or what the correct diagnosis is for this? Obviously, they had years of observing problems with this child without any real diagnosis, solid diagnosis. How do you address the argument, I guess, that that is a valid marital purpose to try to discover and treat the child appropriately?
I agree with you that it's a valid marital purpose if there was a legitimate mystery as to what the child was suffering from. There was not a dispute that the child had something. Hypotonia was the existing and still present diagnosis for this child, which is a low muscle tone, led to a number of physical ailments, and she, in addition to that, had some learning disabilities. So
Explain to me how, without a diagnosis, I mean, if we're going to qualify her as a castle child, and we have a shared parenting plan for what is now an adult, why isn't a guardianship through probate court more appropriate than a shared parenting plan for a person who's now an adult?
that I couldn't address, Your Honor. I don't know that that was ever hashed out in the trial court in this matter, so I'd be speculating beyond the record. I'm sorry.
Back to my question though, at the time, I don't think there was an agreement that this child was a castle child, correct?
There was an initial dispute as to whether or not this child was a castle child. At that point in time, this investigation was done by Mr. McGrew, and later he came to the conclusion, after receiving the reports from Kentucky, et cetera, that he may as well agree to it because the child did have significant limitations. I'll refer you to pages 341 and 343, I'm sorry, 341 to 343 of the transcript, where her existing diagnosis is discussed in the testimony of Sharon McGrew. It's not as if there was some mystery as to why she suffered from hypotonia, as to what the extent of her limitations are, and that sort of thing, but there was no question that this child had significant limitations, and that's really the issue here.
Thank you.
If I have a few minutes left, I will go ahead and move to the attorney's fees issues. With respect to the attorney's fees, the court at pages 19 through 20 laid out its reasoning for awarding attorney's fees, which it has the discretion to do under Revised Code 3105.73A. It's allowed to look at the conduct of a party in awarding attorney's fees, which is set forth in this court's decision in Gross v. Gross, which is in our brief. And in this instance, The court noted that David, in addition to having an attorney die on him, which is regrettable and understandable, he also changed counsel a number of other times, including, I think, 5 other times, filed numerous motions, pro se, sometimes when he was represented, some of them 30 to 50 pages in length, and most of them raising issues that were already before the court. The court found that this required numerous pretrials that both sides had to attend, and it also indicated that this caused Sharon to incur $75,000 in attorney's fees and $10,000 in court costs, which is an extraordinary sum for a divorce. So, with respect to the court's discretion in that regard, the trial court had the best point of view to determine that, having been the one to have to deal with these motions and issues and pretrials and whatnot. And I would suggest that no abuse of discretion has been demonstrated in the trial court's determination in that regard.
Was there a hearing set for attorney fees, or was that just an order?
It was part of the decree. There was no hearing that I'm aware of. So unless the court has further questions, I'll go ahead and yield to Mr. Rosen's rebuttal.
I just want to make sure you agree that the second assignment of error is moot at this time.
According to the conversation I had with my client, yes.
Okay.
Thank you.
Thank you.
Mary Rosen, you have just under 10 minutes.
Thank you very much, Your Honor. Your Honor, let me first address the issue of the CD as raised by counsel. $80,000 was the total debt amount owed on the company. And I would note, and I have a copy of the temporary orders here, they are part of the what was presented to this court as the docket. $70,000 was imputed to husband as being his income from MCS marketing. And from that income, he was meet certain personal expenses and support obligations. But nowhere in this temporary order, which was issued in September of 2011, was there a specific delineation as to which MCS debts he was to pay and in which order. But the income was imputed. It was not actual income. It was imputed by the court at $70,000. The court, Mr. McGrew did not transmute the CD. The court did, and the court called it both separate and marital without sufficient findings. Let me turn to the medical bills that were raised by both sides. Yes, restraining orders are issued by the court automatically at the issuance of a divorce, as this court knows. But a medical bill for a child is the cleanest example of a marital debt that I could propose to this court. If a child sprains his ankle, or if a child has strep throat, and one of the parties gets medical care, that's a marital debt. And in this situation, quoting from page 343 of Mrs. McGrew's testimony, this child's life has been a beautiful, complicated puzzle and wasn't easily or readily diagnosed as to what caused what. That's reading directly from her testimony on page 343 as quoted by counsel. There was not an understanding as to what was going on, which is why the pediatrician said diagnostic testing was appropriate. And I direct the court's attention to page 123 of the transcript for that.
But your client did not initially agree or stipulate, go back to even agree that his daughter was a castle child.
Maybe understand and acknowledge yet, Your Honor. That's a major designation.
Does that have more to do with support payments than it does with any medical understanding?
It also has to do with continuing jurisdiction of the court, because the court will maintain jurisdiction on all issues, not just support, post-age 18 and graduation of high school with a castle designation. And that's a serious designation. And I would certainly always advise a client to look at that with great detail before stipulating to that. And it's very rare that would be stipulated at the very beginning. Thank you, Your Honor. Appreciate the time.